Hello YouTube, I'm Vince White. I'm an employment attorney, and on this channel we answer publicly posted questions from YouTube users, getting folks the answer they need from an employment attorney. Like, subscribe, comment down below. It helps me to help more people like you. And we have a question from TB24. Left out some of that name because it might be a real name. Don't want to put a real name up on YouTube. TB24 says, I have a question. I've got an answer. When does the attorney send the demand letter to the employer after the EEOC case is closed? We did receive a right to sue letter, please and thank you. So, frankly, I don't know why an attorney would wait until after an EEOC was closed to make a demand. That doesn't make a ton of sense to me. But if you received a right to sue letter, you have 90 days from the day you received that right to sue letter to get filed in federal court. So, when should your attorney send a demand letter if you intend to file in federal court? Right away. And then they should start working on that federal complaint to get it filed if that's where you're going. If you're not filing in federal court, things are a bit dicey now because they waited until after the EOC to make a demand, sounds like. And a lot of employers are going to say, I don't know if we want to settle with you because like a lot of people don't actually go on to federal court. So why don't you go ahead and file in federal court and then we'll talk settlement. We're just going to call your bluff here. That's pretty common. So the window between the EEOC and federal court is not always the most fertile place. Listen, you can absolutely settle cases there, and we routinely do. But it's not like the strongest place to settle a case, in my opinion. Certainly, everything that brackets it, like actually being live in investigation in the EOC or being engaged in mediation in the EOC, is a stronger place to be for settlement. And being filed in federal court and having initiated federal litigation is also a stronger place to be. Being in that window between the EEOC and federal court, not the strongest position for the plaintiff. And that's just, like I said, there's a lot of data that reflects a lot of people get right to sue letters from the EEOC, don't actually end up filing in federal court. And so a lot of defense attorneys will tell their clients, hey, this case is a lot of trouble and we should absolutely settle this case if it goes on to federal court. But you could wait and see if this employee actually can get an attorney to take this case on to federal court. You could wait and see. We got 90 days for them to get that done. That's a tight window. A lot of them miss it for whatever reason. Different in every case, I'm sure. And we can just see if they file. And if they don't file, I mean, they're essentially extinguishing their workplace discrimination and workplace sexual harassment claims on the federal level. They might still have state and local law claims. They might have some other federal law claims, But of the cases that would pen through the EEOC, of the claims and the specific statutes that would pen through the EEOC, if you get that right to sue letter and it covers a series of events and then you don't file that case in federal court tied to those specific events that you have your right to sue letter for, you can lose your federal claims on that. And a lot of defense attorneys hope you will. So, should get that demand in right away, but also should be working that federal complaint. Don't know why they waited. But that's just my playbook. I'm not saying they did anything wrong. I'm just saying maybe we're working different playbooks. Like, subscribe, comment down below. Helps me to help more people just like you.